let's move straight into today's topic. So I'm Roopa Mathews. I'm part of the ARBinBRIEF team, and I'm an associate at 𝗔𝗕𝗏 in Zurich. I'll be moderating today's episode on arbitration as a tool to facilitate settlement, featuring Ulrike Gantenberg, founder at Gantenberg Dispute Experts in Düsseldorf, and Dr. Sylvie Bebohi Ebongo, partner at 𝗔𝗥𝗕𝗏𝗏𝗕𝗏𝗏 in Paris and Yaoundé. So first, a very brief introduction to our speakers. Ulrike sits as arbitrator and also acts as counsel. She's a qualified German lawyer and has vast experience working internationally, including in France. She has particular experience with turnkey construction, energy, and post-M&A disputes. Dr. Sylvie Bebohi Ebongo also sits as arbitrator and acts as counsel. She advises clients in a variety of sectors and industries like construction and infrastructure, public-private partnerships, energy and mining, banking and finance, both in Europe and in Africa in the 𝗔𝗕𝗏𝗏 region. So just to set the scene very briefly for our discussion, we all know that there are very frequent complaints about lengthy proceedings and significant costs in international arbitration. And at the same time, parties and institutions also expect arbitral tribunals to conduct proceedings efficiently. So the aim of this session is to discuss how arbitrators can help to resolve these issues of time and cost, specifically by encouraging and facilitating settlement. So with this introduction, the first question for our speakers is how exactly can arbitrators facilitate settlement? And Ulrike, would you like to start us off?
Yes, very happy to get us going. I think arbitrators have plenty of different opportunities to foster settlement. The one may be more successful than the other, but it all starts at the first case management conference. And I think one of the paramount basics is to have the representatives of the parties included. So they need to hear what time we speak about, they need to hear about what the structure is, and they need to see also how active the tribunal is. They can stop it at any time, but at least I think this is a very important first starting point. Me coming from a German region, we are very keen on preliminary views. This is definitely something to be integrated also in arbitration. We have plenty of rules in arbitration proceeding or institutions, but also some arbitration rules or laws per se permit to have these preliminary views hearings. And I think it's a very good tool in the end that brings parties closer to settlement. So the idea of early, it's not an early determination in that sense, but you would sort of foresee and sort of discuss that, of course, in the first case management conference, to have a specific date after the first round of brief or second round of brief, where the tribunal would give a very preliminary review, sort of on, had I to decide today, how would I see things? It definitely clarifies the strength of the case. It also clarifies where the tribunal maybe got it absolutely wrong. So it's something for the parties to correct, but it's also maybe something for the parties to regroup and to see where are stronger key points, where are less stronger points, and how difficult will it be to convince the tribunal at a later stage. So I think these sort of speaking seriously with the parties is very important and very helpful. If we look, for example, in the CEDA rules, these are rules which actually are from 2009. It's this Center for Effective Dispute Resolution in London, which had sort of, with the support of multiple institutions, set up rules. And in their Article 5, they strongly recommend as one of the tools for facilitation of settlement by the tribunal is to really have this early preliminary review session to really bring everybody back on one point. Question is always when at the right point in time. If you're too early, the party will say, well, you don't know it all. If you do it too late, they say, now I've written it all, you know, now we can continue the road. But I think sort of this is definitely something to be discussed at the first case management conference and could be a good way forward to facilitate settlement.
Thank you, Ulrike. Very interesting what you said, especially what you highlighted about it being very common in sort of German-speaking jurisdictions and less so in other jurisdictions. And maybe, Sylvie, you can offer your views on this, as well as any other ways in which arbitrator can encourage settlement.
Thank you, Roopa. I have to say that coming from the 𝗔𝗕𝗏𝗏𝗏𝗏 region, I would base my my argumentation on that region, and I would say that there is not such a practice as Ulrike was saying in the 𝗏𝗏𝗕 arbitration system, except for a provision in the 𝗏𝗏𝗕 arbitration rules, which oblige the arbitral tribunal to make sure that any pre-arbitration step in the agreement, including to negotiate a settlement, have been complied. So you can find this provision on the Uniform Act on Arbitration, Article 8.1, and the CCJA arbitration rules. The rule is the same. But this is really in case you have a multi-tiered arbitration clause and open the request of one of the parties. If the preliminary phase has not been initiated, then the arbitral tribunal shall suspend the procedure for a time period which it deems appropriate to allow the most diligent party to initiate this phase. There may or not be a settlement at the end of that phase, and if there is a settlement, the party may request that the said settlement may be recorded in the form of an award by consent or not. So there is not an active role played by the tribunal within the 𝗏𝗏𝗕 arbitration system.
Okay, thank you, Sylvie. And what other ways could the tribunal perhaps encourage settlement, even if not directly through preliminary views?
Yes, if the tribunal can play a role, even if this is not provided by the law or the rules, by, for example, making a suggestion on how the witnesses can be called, and by putting an accent in the relevant material to their decision. The tribunal can also, and that was the case I had in an arbitral tribunal where I was sitting as a sole arbitrator, can accept to listen to parties if they are present. You know, the party are always represented by their counsel, so they might not be present, but sometimes they can be present, and it is a rare hypothesis, but not impossible. In that case where I was sitting as a sole arbitrator, the party asked to be listened by the arbitral tribunal. So as an arbitrator, I give a positive answer to that request, and we started the hearing by listening after the first the introductory part by the counsel. We started the witness part by listening to the parties. So the party gave really their thoughts about the case, and finally they found that they can settle the case without going further to the hearing. So we had an award by consent after the discussion the parties had in front of the tribunal during the hearing. So as an arbitrator, I encourage that talk with between the parties, and at the end of the day, the hearing didn't go until the end, and we had an award on consent.
Thank you. That's very interesting. And you've touched upon it a little bit, or hinted at it maybe, but what are the sort of risks associated with this type of intervention for the arbitration?
Let's say that one of the risks I see here is that you may be not reach an agreement, and when you don't reach an agreement, there is a probability that your impartiality may be questioned by the party. This is one of the risks really that you may have when you allow the parties maybe, or encourage them to a settlement prior to the hearing. That was one of the risks I had in this case. But particularly in turning back to 𝗏𝗏𝗕 arbitration, what you can have if you act as an active if you have an active role by for example, asking the party to try to settle, you may be put your award into a position of being setting aside, because you have to know that in within the OHADA arbitration system, we have grounds under which you can set aside an award, and one of these grounds is the fact for the arbitral tribunal not to conform with the mandate which it has been entrusted by the party. So one of the party may consider that if the tribunal take an active role, he ruled without conforming to the mandate which he has been entrusted, and he can initiate an annulment action on that ground.
Okay, thank you, Sylvie. That's certainly very important to bear in mind. And do you agree, Ulrike? And is there something you'd like to add?
Yeah, I mean, definitely no arbitral tribunal wants to have the award set aside. Either the award, you know, whatever, it may happen that there is no success afterwards and no settlement facilitation. And this is why I think the most fundamental part is to only do it with the consent of the parties and the very explicit consent of the parties, and have that repetitively confirmed. So I think many arbitration rules, just if we look into ICC rules, if we look into the institutions or rules from the Chinese institution, we look into CEDA, we look into the AS rules and so on, they all say with the consent of the parties or in agreement with the parties. So if in the first case management conference, I would discuss with the parties about, for example, even having an early determination or a preliminary reviews meeting, I would, you know, we would put that in the PO, we would have it in the timetable, because there would be explicit date reserved for that. And sort of before that hearing, we would still ask the parties to confirm by email, are you still willing to have it? It's not only because it's horrible work for the tribunal to really sit down and, you know, find the utmost neutral language to present their facts and views, but it's also just to be safe that at least, you know, at the very last minute, every party could still have said, no, I don't want it. But if they say, yes, we want, and they do it actively, then I do think that it should be difficult to challenge it afterwards, unless for other reasons there's a bias which is created. Yeah. And I think this is more on the psychological part, also on how the parties do play with the tribunal, to be clear that this is just this momentum. And if the dispute continues, it's not that anybody is disappointed, fed up, or whatever. And you may change your mind because this wonderful witness comes, or you got things absolutely wrong, and the parties know now how to better present their case. So I think it definitely, it is a risk, yes, and one definitely needs to be careful about it, but there are ways to live with this. And also, if we even look into the other institutional rules, it's not only the early or preliminary reviews meeting. I mean, there are tons of different possibilities, whether you open up a mediation window and you have an ARB proceeding, you just really bifurcate proceedings, or you do like what I really like, the David Rifkin's idea of the town elder rule, that you really have a decision tree and you take the individual branches and, you know, you do like little salami slices, you know, and decide the biggest chops of the dispute. It always only goes with the parties agree and work with you. But if you have parties who are willing to get to the basics of the dispute and find a good way out of it, then I think sort of that's helpful, and then a tribunal can really do good.
And just one last question before we move to the Q&A. Ulrike, you just mentioned ARBMED. So is it possible for an arbitrator to also act as a mediator in the same dispute? And is there any added value in having the same arbitrator also mediate the dispute? And, you know, what are the risks involved there?
Well, I think that's all the more. I mean, definitely sort of there should be no caucusing, there should be no unilateral discussions. I think this is definitely one of the hygiene minimum rules that have to be respected. So that makes it already difficult to have that kind of mediation approach. And I know also the Chinese, the CATAC rules, to have some provision on that, although I doubt it's put much in practice. But this is, I mean, what the question is like, how narrow do you see the idea of being a mediator? I think this is difficult to really change hats. But if it's like, I tell you my opinion, or as an arbitrator, and I put this, you know, you would go lengthily through the facts and display how the facts are. And then you would not say like, you're wrong, but you would say, you know, then the burden of proof on ABC is on claimant, burden on proof on blah, blah, blah is on that side. You know, you will see whether you can meet that burden. And then if the parties, you know, so the question is really to facilitate a dialogue. It's not mediation in the strong sense. I think that's difficult for an arbitrator, I would say. But then if the parties really want serious mediation, why not pause the arbitration for whatever time and give them the opportunity to really have access to a separate mediator? And I think, by the way, for that, the Cairo Regional Arbitration Institute rules are quite lovely, who just explicitly promote that idea of giving mediation slot a chance in serious arbitrations.
And Sylvie, do you agree, or is there something you'd like to add?
Personally, as Ulrike just said, it's very difficult to change your height especially when you have been appointed as an arbitrator, and maybe during the procedure, one of the parties just asks, can you sit as arbitrator because there is a multi-arbitration agreement, and we want you to sit as a mediator, to act as a mediator, because we will accept mediation if you act as a mediator. For me, it's a very high risk, and personally, in a case when I've been asked to act as a mediator when I was already appointed as an arbitrator, I declined, because I won't do the difference between the mediator and after. If the mediation doesn't succeed, to act after as an arbitrator. So personally, I've not had this kind of experience, and I would prefer to act whether as an arbitrator, I know that I'm an arbitrator, or a mediator, and I know that I'm acting as a mediator, and I can't go further as acting as an arbitrator.
Thank you so much, Sylvie. Very, very insightful to hear that you were asked specifically to be a mediator while you had already been appointed. So that's very
This
insightful.
is the utmost of trust you can have, actually.
Yeah. Yeah, very high praise. So I think our time is unfortunately up, but we can continue the discussion in the Q&A because there's a lot more to discuss. The link for the session has just been posted in the chat, so please do join us there. And I'd just like to say a big thank you to Ulrike and Sylvie for the insightful and interesting discussion. And also a big thank you to our partner organizations, ARBINBRIEF and the Lagos Chamber of Commerce International Arbitration Center for their huge support in making Season 3 possible. And we're also very grateful to the many other supporting organizations of this series. So for those of you watching us on YouTube, our video ends here. Thank you for joining us. And if you'd like to see any future ARBINBRIEF videos, you can follow us on LinkedIn and subscribe to our channel on YouTube.